Our right to wild camp legally is once again under threat, and this time it could be permanent. You may remember this guy, Alex Darwall, a wealthy hedge fund manager who bought 4,000 acres of Dartmoor National Park, the only place in England and Wales where it's legal to wild camp without permission. Last year he won a court case removing that right from us, making wild camping without permission illegal in all of England and Wales, by arguing that the rights bestowed on us by the Dartmoor National Park Act 1985, which gave us the right to engage in any outdoor recreational activity on Dartmoor, did not extend to camping. Pretty bonkers, eh? As soon as it became illegal, he struck up a deal with the Dartmoor National Park Authority to allow permissive access for camping in return for a fee paid by the taxpayer to Darwall and other wealthy landowners in the national park. The deal went through incredibly quickly, which raised a few eyebrows, especially considering that Alex Darwall, the landowner, had paid, I've got to use the word donation, not bribe here, he paid a donation to the Conservative MP for Totnes, Anthony Magnol, of £5,000. Whilst this MP insisted that the donation didn't influence him at all.
I received a donation from the individual who put the case to the High Court. That donation has had no impact on the decisions I make. It's not restricted me in saying anything. It's not made me in favour of one position or another.
He fed the public with lies while he quietly tried to sneak legislation through Parliament to solidify the illegality of wild camping on Dartmoor without permission. Well, luckily, after the general election, Anthony Magnol is no longer the MP for Totnes. And it's actually the first time in 100 years that a Conservative MP hasn't been in power in the constituency of Totnes. Imagine being the first Tory in 100 years to lose that seat. That's a major L for Anthony Magnol right there. Anyway, the DMPA appealed the court case, but only after the public donated the funds to do so, which was odd considering they had the funds to immediately start paying landowners like Darwall for permissive access, but not the funds to appeal the court case. The public won the court case, and ta-da! We, the public, the commoners, once again had the right to wild camp on Dartmoor without permission. That's a brief summary of what's happened up until today. I've gone into much more detail in previous videos if you fancy a deeper dive. But today's issue is that Darwall's now bringing a case to the Supreme Court, once again trying to eradicate our right to wild camp on Dartmoor. If successful, it would mean that we, the commoners, will only be able to camp there once again with permission that will have to be paid for by the taxpayer. Permission that could be rescinded at any time. It's not just camping, it could affect our very right to access the national park. The national parks were originally created for the enjoyment of the public, and it would be an abomination if the public were no longer allowed to enjoy and camp in the only national park where it's legal to camp in England and Wales. If Darwall wins this court case, it'll be final and permanent, and will have no means to appeal and overturn the verdict. This is an attack on our most basic of human rights by the power and money-hungry cartoon villain that is Alex Darwall. If we look at the Supreme Court case, we can see that two issues will be addressed. Firstly, whether the Court of Appeal's interpretation of Section 10(1) of the Dartmoor Commons Act 1985 was wrong. Section 10(1) of the Dartmoor Commons Act 1985 states that the public shall have a right of access to the commons on foot and on horseback for the purpose of open air recreation. So does camping count as open air recreation? What do you guys think? I don't know about you, but I've personally never camped indoors. The Court of Appeal were obviously of the same opinion. The answer seems so blindingly obvious, one can only wonder how the first court ever deemed that it wasn't. The second issue is whether the Court of Appeal was wrong to hold that Pepper v Hart could not apply. Pepper v Hart set a precedent where if primary legislation is ambiguous or obscure, the courts can, in certain circumstances, take account of statements made in Parliament by ministers or other promoters of a bill in construing that legislation. Well, if it's decided that Pepper v Hart could apply, a research assistant to Anthony Steen, who was the MP who sponsored the 1985 Act through Parliament, has publicly stated that they recall no mention of wild camping because it wasn't an issue and was assumed to be included. And now, if we look at the Countryside and Rights of Way Act 2000, through which the public was granted a right to access all open country and registered common land across England and Wales, This act didn't apply to Dartmoor because Dartmoor has its own act. The 2000 Act confers access to the public for the purposes of open air recreation on common lands and common country, but specifies that this doesn't apply to camping, hang gliding or paragliding. Therefore, if the Dartmoor Commons Act 1985 didn't mean to include camping as an open air recreational activity, surely that would have been specified like it was in the Countryside and Rights of Way Act 2000. The fact that it wasn't specified proves that the intention was for camping to be allowed on Dartmoor. I know a lot of you don't really care about the law and wild camp wherever you please, as do I. But there are a lot of people, such as the Duke of Edinburgh and 10 Tours participants, for whom this isn't an option, and a wild camping ban on Dartmoor would completely eliminate their ability to access nature. Maintaining our right to roam and camp on Dartmoor is also a key component of expanding our right to roam and camp across other national parks and nature spots. If you're wondering what you can do about it, well, the Right to Roam and the Stars Are Ours campaign have organised a rally at 3 p.m. this Sunday, the 6th of October at Hound Tor. I'll be there and it'd be great to see some of your faces there too. A group of us will be meeting a little earlier at 1 p.m. at the Hay Tor Visitor Centre for a gentle walk across the moors towards the rally at Hound Tor. This will be led by the lovely Becca from Muddy Bootlaces, so feel free to join us if you fancy a frolic across the moors. And after the rally we'll be walking back towards Hay Tor to enjoy a beautiful Dartmoor sunset. So join us if you can and let's fight for our right to roam on Dartmoor, which is a vital component of achieving a wider right to roam across all of England and Wales.